So greetings everyone and welcome to this International Animal Law Speaker Series event. This series is co-organized by two International Animal Law ABA groups, one chaired by me, the other co-chaired by Dana Bray and Joan Schaffner. A special thanks to both of them for helping to coordinate and advertise this event. If you're interested in learning more about the ABA's International Animal Law Committees and efforts, please don't hesitate to email me at rajreddy@lclark.edu. Our event today focuses on US and international developments concerning the legal rights of ethical vegans on campus and workplace settings. Specifically, our presentations will explore discrimination and harassment faced by ethical vegans by examining relevant case law and harassment in the form of vegephobia. We'll also extend considerable time to interrogating international cases in this arena with an eye towards the landmark UK case of Casamitjana versus the League Against Cruel Sports, as well as a pending case in Canada involving an ethical vegan firefighter. Speaking first will be Jane McElligott, Professor of Legal Studies at Purdue University Global. Notably, Professor McElligott also serves as the chair of the Animal Law section of the Idaho State Bar, as well as chairs the Animals and Science and Technology Subcommittee of the ABA's Animal Law Committee. Next will be Jordi Casamitjana, who also wears many hats. He's a zoologist who specializes in animal behavior and has also worked as an animal welfare consultant, an animal protection campaigner, and an undercover investigator, among other roles. He's the author of Ethical Vegan, A Personal and Political Journey to Change the World, and he'll be speaking to the litigation he brought against the League Against Cruel Sports. Our panelists will be happy to address your questions, which you can submit at any time using Zoom's Q&A function. With that said, Professor McElligott, I'll turn the floor to you.
Thank you, Raj. I will do some screen share here. There we go. And thanks, Raj, and thank you so much, Jordi, for being part of this. I look forward to having you tell everyone your case in person. It's a great way to hear it. So I will just go through. I'll talk about sort of the forms of discrimination against ethical vegans, sort of the psychological, sociological aspects of it, and then we'll get into some of the case law. So again, we'll look at some different types of issues. For example, bullying based on vegan status, the rights of students to opt out of dissection of a frog for biology class, hospital employees' right to opt out of vaccine because it's cultured in a chicken egg. So many of these issues, of course, are ongoing. The issue with the vaccine could be very interesting coming up with the COVID vaccine. We'll also take a look at Ontario, Canada law, as well as Jordi's case that has set a landmark in the UK that hopefully will serve as a persuasive authority in this country and perhaps in Ontario, Canada. We'll also take a look at some of the steps that institutions of higher ed and workplaces could take to bring about more diversity and inclusivity for employees who are ethical vegans. So there's just the learning outcomes that you can check out, but basically just looking at discrimination, harassment, the different forms of discrimination, looking at the US laws that play a part, and comparing that with the UK and Canada, and also, again, looking at some of the proposed changes. So just to define an ethical vegan is an individual who expresses a total rejection of using animals, which extends far past the plate or the grocery store. So, we hear plant-based, people who are plant-based in their diet. That's different than ethical vegan. Ethical vegan is much more, extensive than simply the diet. It extends to rejecting speciesism, valuing the sanctity of all life, seeking to exclude from their life as far as possible, because sometimes it's not even possible. But usually there's many steps you can take to do the best we can. But all forms of exploitation of cruelty to animals for food, clothing, or any other purpose. And ethical vegans embody, of course, that corresponding ethical belief in animal rights. So the two really go hand in hand. That being vegan is really an extension of animal rights philosophy. So a little more on defining it. So again, emphasizing that veganism is not a diet, it's it's an ethical position against the exploitation of animals. And it results, and I think from many of us who have become vegan, it's sort of this evolution that maybe I was vegetarian for several years, then I became vegan probably 5 years ago. I know that Jordi's been a vegan much longer and has thought of things, even as he'll talk about, the pension, what is the pension investing in? Some of the things I hadn't really even thought about. So it is this process that takes a while to work on. But it is really this rejection of the paradigm of oppression and violence that, is part of being against eating meat. And really this whole idea of nonviolence connects so well to ethical veganism. And ethical veganism is not passive, but it's an active refusal to cooperate with injustice. And that's Gary Francione's definition. Oops, I think actually, let me do this as slide share, I'm sorry. Okay, there we go. Hopefully you've been able to, I will go back here just in case you haven't been able to see the slides. I'm afraid to click on the chat just because I don't want to lose the video. But that's the slides I've been going through. Okay, let me check on the chat. Okay, so that is what I've covered, just in case I missed those slides. So there's the definition. If you want to take a quick look at that, I'm sorry, I think I didn't have it on SlideShare. So discrimination against vegans consists of being treated worse than others simply for being vegan. And there's two forms of this discrimination. So there's bias against vegans, which is often referred to as vegephobia. And also the structural reasons, so societal structural reasons, such as not being able to get access to vegan food or being terminated from employment because of the demands of the workplace that are contrary to veganism and one's beliefs. The vegephobia entails this. What it really comes down to is a derogatory portrayal of vegans as self-righteous or judgy, goody two-shoes. So it's part of this form of do-gooder derogation, the putting down of morally motivated others. And this is really implicit when we think about it in our society, in our language. Meat is always thought to be ennobling, and the strong, muscular people are beefy, but lazy people are couch potatoes, unresponsive ones even vegetables. So we see that that vegephobia even in our everyday language. And it also comes through as intentional bias. So, bullying, harassing, ridiculing based on one's status as a vegan. And so we'll take a look at some of these different forms. I also wanted to mention, of course, this is Jesse Grass from the Simpsons, and just kind of one example of how even on a television series. I was actually just recently watching the videos from Lisa the Tree Hugger. And so Jesse Grass is kind of this, he works for Dirt First instead of Earth First as an environmental animal rights advocate. But it kind of, the show sort of makes fun of being vegan, which is sort of because it goes against the norms, societal norms. So it's this, when I'm a level 5 vegan, I don't eat anything that casts a shadow, which of course is kind of crazy, but just representative. So it really is that, sometimes we see this fear and backlash because non-vegans might go on the defensive. And because really veganism is going against a flow and it's rooted in social justice, viewed as a rebuke to the majority's values. Um, and so this brings about, this makes people uncomfortable. Non-vegan people might become uncomfortable in the sense of cognitive dissonance comes into play. So that cognitive dissonance between eating animals and harming animals. So they want to eat the animal, but they don't want to think about that animal is being eaten only because it was harmed. So a vegephobe, not wanting to feel guilty about that, will start to blame the vegan for triggering that cognitive dissonance. And this is even when the vegan hasn't said a word. And if you are vegan and you've gone to dinner with non-vegans, you know kind of what it's like before you don't say anything. And maybe you order a veggie burger, and then it all comes out that, oh, well, I would have ordered the veggie burger. You feel kind of that guilt come into play. But it's almost as if they don't want to hear it, because if there's a vegan at the table, it's going to kind of take away their fun. But there's a definition of cognitive dissonance that really does seem to fit, and it really is. They have the core belief that they want to eat meat, and the vegan is kind of messing with that core belief, so they have to rationalize it. Discrimination against vegans is actually what's called second order discrimination. So it's discrimination against those who oppose the first order form of discrimination. So vegans oppose of course, the speciesist discrimination against non-human animals. So vegans are, primarily about animal rights, the first order discrimination. But then because of that opposition to speciesism, vegans face second order discrimination. And the thing about that is too, that vegans, because they're so focused on the rights of animals and advocating for them, seldom do they worry about discrimination that they might face. And that just kind of, rolls off because it's secondary. And so they view it more as a consequence of another more important discrimination. So the speciesist discrimination. So that's why it often goes unsaid, the discrimination against vegans. And of course, there's speciesism in the sense that we, assign rights not only to animals, non-human animals as a whole. Humans think that, they're higher up on the in the ladder than non-human animals, but then we also distinguish based on the different categories of animals. So while many would find it fine to eat the pig, they would not eat the dog. So that's kind of the whole concept of speciesism. Looking at just some examples of vegephobia and vegan discrimination, one of the cases, and I think it's interesting as I go through these slides, you'll see how when we look at these cases, it's either based on state law or Title VII or First Amendment. There's a whole medley of laws that come into play. As we'll see when we get to Jordi's case, there's one law in the UK that covers it all. So it's so much neater and organized. In this country, we just have kind of a mess of laws that we have to figure out how they're going to apply to veganism. So this particular case, this was in New Jersey back in 2016, but this actually involved a vegetarian child, but pretty close to vegan in the sense that the discrimination was very much close. So during lunch, this one student, and because they're minors, they're just their initials were used, but CC confronts student Casey, and he says, vegetarians are idiots. It's not good to eat. It's not good to not eat meat. And people who eat meat are smarter and have bigger brains. So bullying there. So an anti-bullying specialist was called in by the school, and they determined that CC violated the New Jersey Anti-Bullying Bill of Rights Act. And they said that, yep, this is bullying, that the comments targeted a student's distinguishing characteristic. and substantially interfered with the rights of KS and had the effect of insulting and demeaning him. So a strong case there at the state level that really does bring into play, a precedent that the state, and of course this only applies to New Jersey, but it could be persuasive authority for other states, and serve as precedent that the state's Anti-Bullying Act should be interpreted broadly and extend beyond, the typical categories that are either listed in the statute, race, religion, gender, sexual orientation, to other characteristics that can be, bullying on that basis can be just as harmful. And so the statement's reasonably perceived as motivated by a distinguishing characteristic and having the effect of insulting, demeaning a classmate who's a vegetarian constitutes the same type of harassment, intimidation, and bullying under the state's Anti-Bullying Act. And the good thing is that all states have anti-bullying statutes, and so these could serve as a strong tool against bullying. And for kids, it could even go up to a level, a higher level of education, community college. But it's certainly going to be a strong tool to prevent that kind of bullying, whether it be vegan or vegetarian status. A little more on structural discrimination against vegans. So structural discrimination results from institutional or socially prevalent attitudes. So one of the examples of societal, structural level is vegans have to pay taxes. And those taxes, of course, go to, subsidizing the meat industry. Here in where I am in Idaho, the taxes are going to go to paying bounties to people to kill wolves. So there's this kind of combination of using tax dollars against, the animal rights as well as against the beliefs of vegans. The fishing industry, the animal farming is all being all forms of exploitation are being funded by the tax dollars we have to pay. So this opposition that we may have to subsidizing animal exploitation is just ignored because it's thought, oh, come on, you have to pay your taxes. So it's not taken seriously. So legal challenges that are brought by vegans usually relate to accommodation. So it could be in the employment, the workplace, education, medical care. It could be institutionalized meals, for example, in hospitals, in prisons. And usually we see these laws come into play. So Title VII of the Civil Rights Act of 1964. So this is, of course, the key law that prohibits employment discrimination. And the categories, the protected categories, race, color, religion, sex, national origin. And it does require a reasonable accommodation for religious observation or practice. So we see that's where, where the ethical vegan could come into play. There's also the First Amendment and freedom of speech, freedom of religion, and state anti-discrimination laws, which are often modeled very much like, very similar to Title VII, but they only apply within that state. So Title VII, of course, imposes on a duty on employers to reasonably accommodate the employee's religious practice. Unless doing so would be an undue hardship on the conduct of the employer's business. And religious practice has been broadly interpreted to include moral or ethical beliefs as to what is right or wrong, which are sincerely held with the strength of traditional religious views. So we see that ethical veganism could fit in that definition. And so in order to state a claim under Title VII, the employee has to point to first an employment duty that interferes with the employee's religious practice, and then that there was some kind of adverse action taken against the employee for failing to perform that duty. One of the cases that shows how these two requirements were met is Anderson versus Orange County in California. So Bruce Anderson was a bus driver for Orange County Transit Authority. And he refused to follow this management directive that he was to hand out coupons for free Carl's Jr. hamburgers to passengers. So as they entered the bus, he had to hand them a coupon. And he said, no, I'm not going to hand out coupons for free hamburgers. This violates my moral and my ethical beliefs as a strict vegetarian. So he was actually a vegetarian, but he was very, it was a very strong ethical belief. He was fired for insubordination for refusing to follow the directive. He then filed a complaint with the EEOC, Equal Employment Opportunity Commission, and they ruled in his favor. And so they upheld that his vegan, well, I should have said he was vegetarian, but the status of his belief was so strong that it was more along the line of what we think of as an ethical vegan. But his beliefs rose to the level of a protected religion under Title VII. And so the Orange County Transit Authority wrongly failed to provide a reasonable accommodation. So he won a settlement from his employer for $50,000. So just one case where it shows that, an employee, his refusal to follow an employee's demand did lead to a successful Title VII suit. Another case, the one involving the vaccine, Chinziro is an ethical vegan customer service rep at a hospital in Cincinnati, and she refused to take the flu vaccine because it was produced in chicken eggs. And that one, of course, went against her belief. She was then fired. So she sued the hospital and said her termination violated Title VII because they failed to accommodate her religious accommodation by letting her opt out of the flu vaccine. And the court denied the hospital's motion to dismiss. They said that it's plausible that the plaintiff could subscribe to veganism with a sincerity equating that of traditional religious views. So a couple strong cases using Title VII. This case was based more on a state anti-discrimination statute in Washington state. This is an interesting case because it had to do with a gate Gourmet that provides meals in the airport. So they cited to security concerns, and they said that from now on, employees must eat only company provided food, so they can't bring in outside food. Problem is, all this food was non-vegetarian. Plaintiff was a vegetarian, and he strongly voiced his religious objection. The court said, well, okay, we'll switch from, they had beef and pork meatballs every day. They said, we'll switch to turkey meatballs, which of course still isn't vegetarian. And they said, well, if that doesn't work, then your only option is to work hungry. So this went up to the Washington Supreme Court, and the court ruled that the plaintiff employee had stated a prima facie religious accommodation claim, so a successful claim under the state anti-discrimination law. Another case showing the First Amendment and how this might come into play was that Keith Allison was a second grade teacher, and he was teaching in a school in Ohio when he was out bike riding one day, and he saw the veal crates that were being used. And he took a picture of of a little calf in a veal crate, and he said, as someone who grew up feeling parental love and support, and now as a parent who gives love and support, I reject the claim that separating babies from loving mothers to raise them isolated in boxes can ever be considered humane. So he put this up on Facebook, this picture and statement. Well, it was kind of a small town. The guy who owned the local dairy farm called the school district superintendent saying he should be fired. Well, the school district superintendent went ahead and fired him. And so then the ACLU and PETA stepped in and sued on his behalf. And they did reach a settlement. And they said that, they were able to get him reinstated. The school district issued a written policy clarifying that district teachers have a right to engage in protected speech under the First Amendment, because this was a matter of public concern. So in his role as a private citizen. So sometimes the First Amendment, when one is speaking out about animal rights or vegan rights, that may come into play. Just one other issue that it involves yet another law is the whole issue of dissection in high schools, elementary schools. You may remember there was kind of one of those after school specials of Frog Girl, the Jennifer Graham story. She was a 10th grader in California, and she refused to dissect a frog for biology class. And when they wouldn't let her out of it, she sued the school district. They settled it, and then they did, after that, the state of California at least passed a law requiring an alternative for students from grade school to high school who do object to dissection. So that was a strong win that really started in California. And it has grown to Washington, D.C. and 18 states now. So there's some links that you'll be able to check out, but basically it requires that students have that chance to opt out of dissection when they believe, that this isn't either they're ethical vegans or they're, animal rights advocates. It's a little tougher at the college level or veterinary school level, because these laws only apply to grade school and high school. But there have been cases. There was one in Oregon, Kissinger versus Oregon State, where a vegan veterinary student won the right to take alternative curriculum because this one class involved vivisection. I think it was of a pig, and she didn't want, she said, I can't do that. And so they did let her work around that. So there may be, there aren't too many cases on it, but because of that case, schools may be more willing to work with students. Just some suggestions, and then I'll talk about Canada and hand it off to Jordi. So some suggestions, and I know when I was first started teaching, I remember using a little, just to kind of bring in a little humor, I would say, write this memo for your supervising attorney McGilligot of the law offices of McGilligot Fish and Sticks. And then I went back and looked, and I said, oh, I can't use that. That's, that's against my beliefs as an ethical vegan. So I changed it up now to law offices of McGilligot, Hummus, and PETA. So same thing, but if there are students who are vegan, that's going to be a lot more friendly. Also, the idioms that often people use, the one of kill two birds with one stone is awful, but you can change that up and use it in the classroom. Feed two birds with one scone. How much better is that? And I'm teaching legal philosophy right now, and I had added in a topic on animal rights, animal welfare, and looking at the philosophy behind it. So the cool thing is animal rights, veganism, they fit into so many different subjects when we think about it. Everything from legal philosophy to regular philosophy, environmental policy, ethics, science, psychology. So almost every subject. I don't know about maybe math. Math might be tough, but most subjects are fit for issues, whether it be written assignments or discussion boards or just discussing it in seminar. A great place to bring up these topics of veganism or animal rights. Also, a lot of times when you go to as faculty or as employees of companies, you have to go to a conference, and what is being served, nothing but those little meat sandwiches. It's really difficult sometimes to be able to get food that is vegan. And so by being either workplaces or universities making vegan food sort of the new normal, it's a nice way for everyone to, no one to feel left out, and everyone kind of gets to experience how good vegan food can be. And it doesn't, it doesn't bring about that harm really that ethical vegans feel that, oh, look, this all that's being served is all this meat. Um, and there is also this disconnect when this one author points to the disconnect when faculty gather to discuss, important issues, discrimination, exploitation. But then, as he phrased it, they're enjoying small animals for lunch. And some people will notice the hypocrisy and the judging of, how the animal rights movement has grown. And maybe this would help bring about more discussion if the food was more fitting. Um, and as this author said, we can all do our part to respect the rights of our non-human animal friends, especially at meal times during our scholarly meetings and conferences. Rather than tolerating nondescript meat sandwiches, stand up for others whose marginalized existence can be seen on that plenary session lunch plate. And also, I just wanted to point out, Jordi's going to tell his whole case, but just wanted one slide on here to show that after we've gone through all those laws, the First Amendment, Title VII, state anti-discrimination laws, all that mishmash of laws, as you'll see in Jordi's case, it all in the UK, they fit it all under one nice law, the Equality Act of 2010, which is also important because it helps set a strong precedent that applies to so many different areas. So I will let him talk about that, but I did want to point out his excellent book too, that just came out very recently, and I am loving it. So it's a great read. The only case I wanted to mention before I hand it off to Jordi is this pending case in Ontario, Canada. That's a picture of Adam. I'm not sure if it's Knopf or Knopf, but he is a firefighter for the Ontario, Canada's Ministry of Natural Resources and Forestry. And he was deployed to fight this massive wildfire in British Columbia. So he's out there working, cutting the brush and doing all this very physically demanding work for up to 16 hours a day. 10 days of this work, very hard work, exhausting conditions, trying to save these homes from, people losing their homes. Despite all this work, his extreme hunger that would come about with working this hard, he just couldn't get any food. He kept asking for some vegan food because he was an ethical vegan. And at one meal, he got a single black bean. So he was complaining. He said, come on, I need something to sustain me. I can't just live on salads out here working 16 hours a day. One day they finally gave him a veggie burger, but the chef had just been handling meat burgers and then put his hands in the veggie burgers. So he said, this was contaminated by the animal products. He's starting to feel physically ill, mentally groggy. There's the part about the veggie burgers. The day after that, his lunch was, they said it was vegan lunch, but it was half non-vegan, and he just kind of lost it. He said, this isn't vegan, and he threw it out, and he cursed. He cursed a couple of times, but the guy was starving, and he was just very frustrated. So you can see why he would have let out a curse or two. His supervisor then disciplined him, sent him home. He then filed a complaint with the Human Rights Tribunal of Ontario. He alleged that his employer has violated his human rights and discriminated against him by failing to accommodate his sincerely held ethical beliefs, so creed under the Ontario code, by failing to provide him with food reflecting his commitment to ethical veganism. And by the way, he couldn't go get food anywhere else because they're out in the middle of the woods fighting a fire. The whole place had been deserted. So it was he was pretty much forced to go hungry despite having to do all this work. So this is the first case in which this Human Rights Tribunal in Ontario, Canada will determine, is veganism a type of creed under the Ontario Human Rights Code? And this follows, the code had recently been updated, 2015, to include non-religious principles. And so the way it was defined is which, like religion, substantially influence a person's identity, worldview, and way of life. And you can certainly see how ethical veganism would fit that definition. The code provides factors to look at to determine whether a belief system is a creed. And so things such as, is it sincerely held, freely and deeply held, integrally, integral, I have issues with that word, integrally linked to a person's identity, self-definition and fulfillment, is a particular and comprehensive overarching system of belief. So as you look at these factors, it seems as though ethical veganism hits each one of them. Really issues about life, the order of existence. Does it have some nexus to an organization or community? There's certainly, we would say, ethical veganism hits each one of these points. And in his complaint, he clearly set forth the strength of his belief, saying that his decision not to eat meat, fish, dairy, eggs, or honey is a philosophy that goes to his very core of his identity. And he also said, I am an ethical vegan in that I not only follow a vegan diet, but he extends the philosophy of non-consumption of animal products to all other areas of my life. I do not think that humans have a moral right to oppress other beings or to cause them pain or suffering. So we see the core of his beliefs here. And he pointed out too, he's been an practiced ethical veganism for over 20 years. And it certainly does look like this belief system he has goes to the heart of his identity, worldview, and way of life. So thank you, everyone. With that, I will stop my share and let Jordi tell his case in first person here.
Okay, let me share my screen now. Okay, this is me, Jordi Casamitjana. I am a zoologist, an author, a campaigner, all the things that I've been described with. What I'm not is a lawyer or have any law degree. So anything I'm going to say about law today is just my view from a non-lawyer point of view. I have been involved with laws many times in the prosecution side, in the defense side, in the jury side. So I know a little bit about it, but I'm not a lawyer. So I don't want people to assume that what I'm saying is at the same caliber than anybody that had a degree. Right, let's start with my case. My case started in 2018. Part of the things I've been doing through my life has been working either as a freelance or person or as an employee of animal protection organizations. And in 2016, I joined an organization called the League Against Cruel Sport, which is against hunting, which I had worked with them before 10 years earlier, so I knew them quite well. And what happens is that when you join any organization or any company in the UK since the last few years, it is compulsory to auto-enroll each of the employees into a pension fund. And this pension fund is one chosen by the employer. And as I am an ethical vegan, almost been not 20 years an ethical vegan now, any time there is something involved in a choice or money or things like that, I always check where the money goes. So I always check the pension funds where they invested into. And in 2017, I learned by contacting the pension provider that the companies that the pension fund was invested into were the ones I would consider the worst possible companies from an ethical point of view. Tobacco companies that test on animals, pharmaceutical companies that do vivisection, gas companies, petrol companies, all these companies that I was surprised were going to be invested into for an organization that was an animal protection organization, especially considering that 10 years prior, they had a pension fund with the label ethical in them. So it had been a change of pension fund. So I was quite surprised, and I told my bosses, who blamed the previous management, but they said they would look into it and they would change it, because obviously there was an issue of reputation. There was many of my colleagues were vegans like myself, and they didn't know this. And also there were the organization depended on donations of people that probably would not donate if they knew the percentage of their money would go to this sort of company. So there was a reputational issue, an issue of my colleagues and my own personal issue. So they said they will look into it, but a year passed with many attempts to change and also many changes in management. And a year passed and things have not changed, despite the fact that at one point, the manager in charge had told all the staff that they had found an ethical fund that was no longer invested in these companies, and they would now change it by, if they didn't, an employee that didn't complain about the change, automatically they will be changed to that one. And in January 2018, which is the time that by December 2017, that should have been done. In January, I checked, and it hadn't been done. And when I had a conversation with the general manager, that later became the CEO, because the CEO prior had been ill and had to leave, eventually they told me that that change might not happen. Yet all the employees assumed that had already happened. And if you don't like your pension fund, that the pension fund that the employer provides you, you can always change it yourself, but of course you need to know there is something wrong with it. So eventually I felt that I had to tell my colleagues, my vegan colleagues and the rest of the staff, what I knew, which is that this pension fund had not been changed despite they assumed it had. That in fact there were 9 ethical funds in that pension provider they could choose to, and I told them which one they are, and I didn't tell them which one I chose, so not to influence them. So I gave them all the information they needed to change the pension fund, since it seems that they had to do it themselves. And as a consequence of that communication with my colleagues, which didn't go beyond the organization, just with the colleagues, I was fired. I was fired for failure to follow reasonable management instructions and for serious insubordination. And allegedly, they said that that instruction was not to communicate to my colleagues about the pension issue. So what happened is I felt that that was unfair. I also looking at the letter of dismissal and at the recordings of my disciplinary hearing, I noticed that they mentioned my ethics several times, such as my ethics clouding my judgment, etc. I realized that the actual reason of having been fired rather than being punished in any other way, if they considered that I had something wrong, was that I was an ethical vegan. And I thought that was discrimination, and I thought I had a case for unfair dismissal. And this is the case that, so I took my former employer to the Employment Tribunal that deals with this sort of issues, and this is the case, Casamitjana versus the League Against School of Sports. ET means Employment Tribunal. My claim, which was many pages, is more or less summarized with this sentence here. I am an employee who was dismissed by an animal welfare charity after I blew the whistle that the pension fund was being invested in companies involved in animal testing. As a result of my protected disclosures, I suffered a series of detriments, including my dismissal, which I claim was discriminatory on the grounds of my philosophical belief in ethical veganism. And as you can see, there's 2 things in yellow there, blew the whistle and discrimination, because I used 2 different laws. Discrimination is in the UK is done by the Equalities Act, but the Employment Rights Act is illegal to do something negative, something bad to anyone that blew the whistle. Of course, the definition of what means to blow the whistle is very strict, but I realized that my communications, my disclosures to information to my colleagues kind of fit the definition of whistleblowing. So there were 2 potential breaches here of 2 potential laws, one for whistleblowing and the other for discrimination. I was trying to get them both, and both are dealt with employment tribunal. But the question was my belief protected? Was ethical veganism a protected characteristic? And I think in the UK, in the US, you use the term protected class. In the UK, we use protected characteristic. And the way it works is a question mark. If that hasn't been tested in court, it might be yes, it might be no, because for each belief that hasn't been tested in court, a judge has to decide if it's protected or not, following a series of characteristics that were already set up in a higher court, which is the Employment Appeals Tribunal. The way it works is the Employment Tribunal is the one that has to decide whether a belief is protected or not. And it does it in a pre-hearing. In any case, there will be a pre-hearing before the big hearing, where the question of whether that belief is protected is going to be answered. And after that will be the full merits hearing, where the question of whether the person was discriminated against was true or was false. So before going into the discrimination, the judge had to look at the belief as such. And in this hearing, had to answer two questions. Well, in this case, whether ethical veganism fulfill all the conditions to be a protected philosophical belief under the Equality Act 2010. And the second question, whether I was a genuine person holding this belief, because I could made it up or just did it for the purpose of litigation. It has to be, the judge had to have the opportunity to check whether that belief is genuine. I do hold that belief. These are the only two questions that have to be answered. And if the question is yes to both of them, then the case continues in the full merits hearing to determine whether the reason of my dismissal, in my case, was that discrimination or might have been another reason. So this pre-hearing happened in Norwich, the 2nd and the 3rd of January 2020, in the Majestic Escort in Norwich. And it was successful. There was a lot of interest already when I started making public that I was going to do this, because I didn't have the money to run this. I had to crowdfund. And because I had to crowdfund, I need to make the story public. Therefore, there were a lot of interest. Some people are thinking I had no prayer to win, and it was impossible. People laughing at it, people criticizing. But the world was really looking to this because there was no precedent in anywhere else. So there were a lot of press on the day. And on the same day, which is unusual for Employment Tribunal cases, the judge gave a verdict. He gave a verdict because he knew there was a press outside. Normally, you have to wait a few days, and he will send you a written judgment. In this case, he asked us whether we wanted a summary judgment on the day with all the press. It was full entire room. There was no room for anyone else. And then he would send us the written judgment later. And we said yes, and he said that yes, ethical veganism was a protected belief. And of course, the whole world commented on this. Obviously, the vegan press first, but all the press in the UK, the Guardians. In fact, my face was in all newspapers the next day in the UK, all TV, the BBC as well, all the radios. In Europe as well, not just in the UK, Euronews, in Switzerland, in Portugal, in France, in Italy, in Spain, and beyond Europe, in the US, Washington Post, in Russia, in New Zealand, in Turkey, in Israel, in China, in Korea, in Japan, Peru, everywhere. In fact, the last time I checked, 1,467 websites from more than 60 countries talking about my case. So it was one of the huge stories about veganism. Who achieved this? What was the legal team achieving this? Well, I was the claimant. In the jargon of Employment Tribunal cases, the person make the claim is called the claimant. So what would be the plaintiff in this case is called the claimant. The other person that in the UK and the US would be the defendant is called the respondent. So it's the claimant versus the respondent. So I was the claimant, and I used a solicitor, which is Peter Daly, the one in the middle, from the firm Slater and Gordon. In fact, he worked for another firm called Bymans when I started this case, but then he moved to Slater and Gordon. And because it was very good, I was very happy with him. Rather than getting another lawyer for Bymans, I moved with him. So the case started as Bymans' case, and then moved to Slater and Gordon. And then we hired Chris Milson as a barrister to represent me on court, and he's for the firm Cloisters. And on the other side, we have the two witnesses I produced in my side. We were three witnesses in my side. Jeanette Rowley, which was a member of the Vegan Society. Also, he ran the Vegan Rights Alliance, and he's an expert in these sort of things. And a professor of moral philosophy of Oxford University, Professor Jeff McMahon, was also the witness. But what happened in the day is we had 2 days. The first day, because I produced more than 1,200 pages of evidence to show that I was a genuine vegan, but also just to show that all the conditions that need to be fulfilled for a belief to be protected, which I'm going to mention in a minute, they were all fulfilled. The judge needed time to read all that. So the first day was entirely for the judge to read all my evidence. So then second day, the third, we were going to give oral testimony, but he didn't ask any questions. And what happens with the other side, with the respondent, is in the process of disclosure, when we interchange of the evidence before the case was heard by the judge, the other side, the respondent, considered that ethical veganism was protected. For a moment, we thought that that concession meant that the pre-hearing would not go ahead. But the judge insisted that it had to go ahead because he had to check all the conditions. And the concession was not enough because it might not have been done following all the conditions that had to be fulfilled. And he also had to check that I was a genuine vegan, and the fact that the respondent believed so, that was not good enough. So the pre-hearing was going ahead, but because there was a concession, there were no questions from the respondent to any of the witnesses. And the judge had already made his mind by reading all the evidence. So he didn't ask any questions to any of the witnesses I produced. We all produced a written testimony, which he had read the day before, but he didn't need to ask us any questions because everything was in there. And of course, I had a lot of support of the vegan community because, as I said earlier, I could not afford my lawyer, so I had to crowdfund for the legal fees. I use a crowdfunding page called crowdjustice.com, specialized for legal cases. So every donation was going straight to the lawyers, and many came to support me on the day. But I also want to mention a precedent case. Joe Heisman is a friend of mine who helped me in this process, but he helped me because he was part of a case that works as a precedent of mine up to a degree, a precursor, I would say. That's his case, Heisman versus Milton Park in 2009. He is also vegan. He also was fired, but he didn't claim veganism as his belief. He claimed the belief of the sanctity of life and the belief of being anti-hunting. Because at that time, he didn't think that veganism would work. That was many years ago. That was prior to the Equality Act 2010. He was using the previous legislation. So he won, but that didn't create precedent since he didn't use the term vegan in his definition, and there was another law, not the Equality Act itself. But it did help us to show that there were cases of a similar nature that had already been accepted as a genuine beliefs. The Vegan Society also helped me a lot when I could not reach all the money I needed to pay the lawyers for the pre-hearing. They gave me the rest of the money. So only for the pre-hearing, not for the full summary hearings. They could not help me on that part, but they could help me on the pre-hearing since that would affect all vegans. And so thanks to them, I could afford the legal representation, which was very important. Which laws are we talking about? Well, there are many laws that could have been used, but only one was used, because we have a Universal Declaration of Human Rights that in Europe led to the European Convention of Human Rights. And I could have used that if I had no other law. Being at the time still part of the European Union, UK was still part of the European Union, I could have used human rights legislation at that level, which in the UK, it was translated into a Human Rights Act. I'm sure you already know, but the way it works in Europe, the European Union, the European Parliament, what it does is creates directives, doesn't make laws, makes directives. In directives, what it do is inform each of the member states, the governments of each member states, that they have to create their own laws in line of those directives. So the directive is not a law in itself, it's just an instruction to each of the governments with a particular amount of time to create a law that deals with that issue. So the European Convention of Human Rights directive led to the Human Rights Acts in the UK and the Equality Act as well, because there was issue. The European Convention also said that you should not be discriminated because of your beliefs. So that idea of not being discriminated because of belief comes from the Universal Declaration of Human Rights and ends up in the Equality Act 2010. So there's another case before mine that is relevant for these discussions, Conisbee versus Crossley Farms, because that was a case of a vegetarian claiming to have been discriminated for being a vegetarian. And the interesting thing about this case is it was the same judge than mine case, Judge Puzzle, Employment Tribunal Puzzle, that ruled both cases. And this was a few months before mine. And the most interesting thing of all is that he ruled that vegetarianism is not a protected class. It's not a protected characteristic. So he ruled that veganism is a protected characteristic, but vegetarianism is not. Why? Because there are a series of conditions that have to be fulfilled, and he thought that vegetarianism had failed one. How the Equality Act works? Well, it defines that are protected characteristics that you cannot discriminate against people for having them: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. One of them is religion or belief, and it goes and explains a bit more about this. It says religion means any religion, and a reference of religion includes a reference of lack of religion. That means atheism would be included into this. And then it's the first time they use the term philosophical belief. It says belief means any religious or philosophical belief, and a reference of a belief includes a reference of a lack of belief. So we have the term philosophical belief to make a distinction between a philosophical belief and a religious belief, which means in practical terms, this is how it is interpreted. A philosophical belief is a non-religious belief, any other belief that is non-religious. And some that make it easier for veganism to be a protected belief, because we don't have to say it's a religious belief or even that has a structure of religion. You only have to say that is a philosophy that is not belief, not religion. But in the Equality Act, if you claim that you follow a particular religion, recognized religion, you go straight into the false marriage hearings to see whether that was the reason of your dismissal or do you do decrement. But if you claim a protected belief, then there is a step that has to happen, which is a judge has to check that belief to be sure that no weird or belief that shouldn't be protected sneaked in. So a judge has to look into it and decide whether the belief is protected or not. So when you claim non-religious belief, a philosophical belief, then this step has to happen. And it has to follow these that were set up by a previous case by the course that is above the Employment Tribunal, which is the Employment Appeals Tribunal, the EAT. And this was the case that generated the conditions, Nicholson versus Granger. Since then, that's because the Employment Appeals Tribunal has automatic precedent power, so anything they decide automatically should be applied below. That means all the cases of Employment Tribunal that have to choose, have to decide whether belief is protected, not have to look at these 5 points here and check whether that belief fulfills them all. If it does, then it's protected. If it doesn't, any of them is not. Which are, be a generally held belief. It cannot be something that you just have an opinion that you don't really believe in. So that has to be the first point. Second, be a belief and not an opinion or viewpoint based on the present state of information available. Means it's not that you learn about something and you have an opinion about something. It has to be something that you are certain about. Being belief is almost synonymous of conviction. You are certain about, either by logic, either by faith, either by common sense, whatever. You have make a change in the way you look into this, and now from that point onwards, you're certain about it. The third, be a belief as to weighty and substantial aspect of human life and behavior. It cannot be something trivial. It cannot be something that only affects a tiny aspect of your life. It has to be affecting a substantial part of it. 4, attain a certain level of cogency, seriousness, cohesion, and importance. And this is the important one, because up to now, they were only looking at the structure of the belief. It had to be a belief, it could be anything else. Now it's looking at the belief itself, and it says it cannot just be something that makes no sense. It cannot be something that is trivial and unimportant. It has to be have a certain level of cogency, seriously, cohesion, and importance. Not completely a very important, certain level is enough, but it has to be certain level. And the fifth one is the one that affects others, the social component of it. Be worthy of respect in a democratic society and not incompatible with human dignity or in conflict with the fundamental rights of others. In a way, you can see it's 3 points in one, because the 3 should happen: the worthy of respect, the non-incompatibility with human dignity, and the fundamental rights of others. And this is the one that many failed. For instance, there have been attempts to get neo-Nazis believe in Nazism protected, that failed because obviously negatively affects the fundamental rights of others. Islamophobia failed. Many of the bad beliefs have failed because of these conditions are good enough to detect them and to show that they shouldn't be protected. Vegetarianism failed for number 4. According to the judge, Puzzle, it didn't achieve a certain level of cogency and cohesion, because the reasons why vegetarians are vegetarians might be very diverse and might not necessarily be based on ethics. It might be just be based on faith. It considered there was not enough cohesion in the structure of the concept of vegetarianism as it was defined by the person in that particular case, compared with how I define veganism, and how, because there is a definition, because it's very strict the way it's defined and clear. And that is the distinction that makes one protecting the other was not. Protected from what? Well, the Equality Act covers a lot, covers discrimination, harassment, and victimization. Discrimination in two different ways, direct and indirect. Direct meaning the person has been discriminated, that particular person alone for having expressed a belief or whatever other characteristics. Or indirect is when whoever is discriminated, being an organization or a company, has a rule that discriminates all those sharing that characteristic, not just that person in particular, but anyone else. So it's based on a structure. We were hearing this part of a structural discrimination before in the previous talk. Well, this is very explicitly expressed in this. Indirect discrimination is when there is a structure in the rule system that discriminates a group together with these characteristics, while direct is just that person in those circumstances. Harassment will be being the victim of an unwanted behavior, being mocked, being harassed, being insulted. And there are many points there that make sure that nobody can just claim harassment without a good reason. If a third person observing it doesn't feel that there was an intention to harm or to harass the other person, that would not count. It has to be a genuine harassment. It cannot just be somebody making a joke that you are offended, but nobody else is offended about it. It should be clearly there was a bad intention. And victimization, meaning that if you complained about being harassed or discriminated and you started procedures using the Equality Act, and then because you complain, you are sacked or you get prejudice or you get decrement because of your attempt to solve that problem, then you've been victimized, and that's also protected. Where? Well, everywhere, and that's what I was saying earlier, Jane, that this law really covers everywhere. Covers all workplace, and it covers employees and contractors. Doesn't matter whether you have a contract, a short-term contract, part-time, everything. Also premises in the relationship between landlords and tenants. If a landlord says, I don't want vegans in my house, that will be discrimination. Also the provision of service, both private and public. Hotel, hospital, school, private, a hotel, a restaurant, things like that. But it only covers Great Britain. As you know, Great Britain is England, Wales, and Scotland. UK is adding Northern Ireland to this. Northern Ireland, the Equality Act doesn't apply to Northern Ireland. Therefore, in my case, does not apply to Northern Ireland, but does apply to England, Wales, and Scotland. Often, because of devolution, England and Wales and Scotland have their own laws because they handle their own parliaments. And most of the laws these days, they are different in each of these regions, but some are still the same. And this is one of those that are still the same. The Equality Act does cover Scotland as well, even in many laws don't cover Scotland. And what did the judge say? Well, he produced the written judgment, 28 pages, with a lot of details explaining his reasoning, and they are all very good. This is the first page of it. I'm just going to mention some of the things that I think more important. The paragraph 13 is the one that talks about what is an ethical vegan, because obviously only ethical vegans are protected, not anyone claiming to be a vegan or not somebody just eats the food the vegan eats, or a dietary vegan or plant-based person. It has to be an ethical vegan, so they have to be defined somewhere. And it says the definition of contained or provided by the Vegan Society is helpful in that defines vegans as follows: a philosophy and a way of life which seeks to exclude, as far as possible and practical, all forms of exploitation and cruelty to animals for food, clothing, or any other purpose, and by extension promotes the development and use of animal-free alternatives for the benefit of humans, animals, and the environment. In dietary terms, it denotes the practice of dispensing with all products derived wholly or partially from animals. This is the current definition of the Vegan Society, created in 1988. The society was the one that invented the term vegan in 1944. When it was created, it was a splinter group from the Vegetarian Society. And it took them years to perfect the definition until in 1988, they found that definition is still the same. So an ethical vegan is one that follows the definition of the Vegan Society. That's how I define it. That's how many do. So you could also call it a true vegan or a proper vegan, because those that only use part of the definition, even if they define themselves as vegan, they are not actually following the definition of those who invented the word vegan. And point 16, the paragraph 16, the judge says, the philosophy defined by the Vegan Society is clearly one that the claimant adheres to and thus constitute the basis of his philosophical belief, acting as a moral framework. And that means that anybody else is following the same definition will also be protected like I was. So because there's a specific definition, and I used that one, I didn't use one that I created for myself. I used the one that is most commonly used by ethical vegans. The judge recognized that that is what encapsulated what an ethical vegan is. That's why my case has relevant to all the vegans, because it's based on a definition that is recognized by ethical vegans. And then that's the last part of all. He said, I am therefore satisfied and find it easy to conclude that there is an overwhelming evidence before me that ethical veganism is capable of being a philosophical belief and thus a protected characteristic under the Equality Act 2010. He used this term, overwhelmingly evidence before me, and easy to conclude. This is an employment tribunal case. This is the lowest possible case. It could have been appealed, and then the Employment Appeals Tribunal case, tribunal would look into it. But because the other side didn't contest it, it was not appealed. There is a chance that other judges might, in the same level, might decide in the future differently. But that has never happened. Every time there is a belief that is accepted by a judge at the Employment Tribunal level, it hasn't been appealed, is normally recognized by all the other judges. But let alone one strong wording, easy to conclude, overwhelming evidence. And remember, I produced more than 1,000 pages. So that means, in fact, even if it didn't go to the Employment Appeal Tribunal to seal that is definitely a precursor, that a precedent needs to be followed by others, it has the same effect. So it's in effect a precedent. What happened with my full merits hearing? So in February and March, there was a 10-day trial to see whether that was the reason of my discrimination. Because the first case was, the first pre-hearing went very good for me. I decided to drop my claims of the whistleblowing part, the Employment Rights Act, and concentrate on the the Equality Act only. And actually, I added another victimization case in that make it easier for the judge to deal with only one law. And after the 5th day, it went very well every day. After the 5th day, there was a settlement. Both sides got together, and it was a settlement in my favor. I got all the compensation I wanted to or asked for. And there was also a statement produced by the respondent saying that I had done nothing wrong in my communications with my colleagues on the pension issues, and I did it motivated by my ethical veganism. And actually, they thanked me because they changed their pension fund as a consequence of my complaint. So it was definitely a victory, even if it was a settlement. And as a consequence of this, the pandemic started immediately afterwards, so I had time to do nothing else, to stay at home. So I wrote a book telling the story about my case, plus the story about how I became a vegan, plus the story about veganism as a whole, the whole story of the whole thing, these 3 stories. And this is the book Ethical Vegan has been published in the world since December and since last month in the US. And other people well, effects happen all over the world. There are many things, consequences of this. Actually, there was an Italian case a few months later in Bologna, where an Italian teacher had complained that she didn't have vegan options in her dinner, while the pupils had it, because there was a directive from the Italian education minister that the pupils should not be discriminated, but the teachers didn't count. She complained, and eventually she won the case, and she got the compensation. And as you can see on the right, you can see an article talking about this with my face on it, because it was one of those consequences that people said that this case actually was brought up because people felt now that they could try the same thing in their own country. So that was a legal consequences on my case, even if it's not direct precedent. But there were other things happening in the UK. The fire brigade now issues automatically vegan equipment with non-leather to the vegan firefighters. That didn't happen before. Many people contacting me that after fighting in the schools where the pupils didn't get the vegan meal, now they have it. Many anecdotal cases were occurring all over the place, but suggesting that people were assuming that, yeah, this is now the new normal. We need to look at vegans differently, and we have to treat them as anybody else. And this is it. So thank you very much. I'm happy to answer any questions that I can have.
Thank you both, Jane and Jordi, for those excellent presentations. And we have a few minutes for Q&A. So please let those, please submit those to the Q&A function here in Zoom. We have one that's already come in. So this one, I think, is for you, Jane. So linguistically, why vegophobia rather than vegism? Is it a fear of or biased against?
Yeah, yeah, great question. Yeah, the term vegephobia is used to be when, say, a non-vegan person has a fear or dislike of a vegan, and usually it's because it brings about that cognitive dissonance that creates kind of that uncomfortableness, and that of course results in discrimination or bullying or harassment.
Okay, thank you. This question is for you, Jordi. I know the UK is no longer part of the EU, but I know that there are a lot of halal slaughter cases that are coming through the EU sort of human rights courts. And I'm wondering, with respect to the Crossley case, those sort of elements that you listed, what would happen in a situation where, let's just say, where 40 or 50 years we've progressed in terms of sort of eschewing animal products and becoming a more ethical society, and somebody would say, my rights as somebody who consumes animal products are being violated as part of my deeply sort of held beliefs. I noticed that fifth element, you cannot harm the human rights of others or fundamentally harm others, and that last element doesn't include humans. And so I'm wondering if you think that would prevent a similar claim, but just from the other side of the aisle.
Yeah, I actually have been asked this question many times, yes, I think it would, because one of the consequences of having this law for 10 years, more than 10 years now, is that we can see it in practice, which beliefs have passed and which they didn't. And when you look at them, the ones that you think by common sense they should pass, they pass. The ones that they shouldn't pass, they didn't. For instance, the one that passed, pacifism, has been approved. Environmentalism, veganism, the teetotalism, not drinking alcohol. The ones that fail, Islamophobia, Nazism, all these bad ones. Because, but often what happens is that if you create a belief that is protected, if somebody builds another belief against that belief, it has a lesser chance to be protected too. If the whole purpose of your new belief is to go against somebody else's protected belief, that will be considered a failure of point number 5. So if somebody says, I'm now going to create a new belief called anti-veganism, veganphobia, or call it differently, and that is what I feel I have to be protected against, that would not progress, because they would have created something against a protected belief, in the same way that Islamophobia is against a particular religion already established. So that's a level of protection, is that the fact that we got first give us an advantage that anybody kind of campaign or trying to create a belief against our beliefs will have it more difficult. But then it has to be more than that, because what I have to prove is what that section says that is important, is coherent, all these sort of things. I had to just give the pedigree, the history. There is an organization based on veganism, has been defined. So all these elements that at least give legitimacy to the belief as a philosophy, they should produce the same thing. They should not be able to create something as a reaction of vegans. They should have to say genuinely, the carnist society, we could call whatever they call it, was created 3 centuries ago, wherever. And carnism doesn't work like this. Carnism is being part of the general culture, moving in all levels, but not in an organized and well-defined and a structured way, so you can join or not join it. It's part of everything, but not a specific group with a specific philosophy that you can decide to follow. So that means that will make it more difficult. Right now, but if we talk about 100 years ahead, perhaps there will be 10 time for this other belief to develop and have a structure, and it become much more feasible then. But then we obviously will be talking about a culture where hopefully we're moving closer to the vegan world, where it will become also more difficult for this succeed. But I would not have any problem for having a vegan world where everything is vegan, animals are not exploited, and have the rights of a carnist protected. So somebody has the right to be very upset about that vegan world. He cannot eat animals because that will be a break in the law. In that vegan world, there will be laws like that. But you have the right to that belief and to be upset. That would not be a problem for me. But obviously that we're talking about many generations ahead, if it ever happens. But at the moment, I think the experience of the UK system show us that, yeah, the opportunistic belief that comes as a reaction of something being protected, as almost a bigotry towards that protection, fail. They fail. So.
Thank you. This question is also for you, Jordi. What was something that surprised you or was unexpected as you moved through your case?
Well, the first surprise was I thought it was protected from the moment I was fired. I thought that would be an automatic thing. I would say I'm vegan, and say, oh, wonderful. You classify perfectly as a belief, because obviously I knew it was a belief. I look at the law, it says philosophical beliefs, that's fine. Then I learned the process I had to go through to be approved. That was the first surprise, because the Joe Heisman case that I mentioned earlier, the precedent, had created an impression to many vegans, including myself, that that was the thing that made it. But then talking to Joe is the first person I talk about my case. When I was fired, I went straight to him and then learned the details about the case. Then is when my first surprise, oh, it's not really protected. There's a higher chance that we'll succeed, but I have to be the first one. That was the first. But apart from that, from the day one, I knew that was a good case. I knew I could win it. I worked hard, had good lawyers. I removed the variability of failing. Still is always a chance. You never know. The judge might be somebody that hates vegans. But I was lucky in that regard. And actually, the fact that I knew that he had judged against vegetarianism a few months earlier, that helped my case and my confidence, because reading that judgment, he did mention veganism almost as passing, saying, this is not like veganism. And that made me think, he actually sees a difference, between the two. So it was a lot of luck through the way. But the first surprise was 21st century, modern European country. It should be protected already. Why is it not? That was the first.
Thank you. We have one last question. This one is for Jane. You mentioned just you canvass sort of a wide number of areas in which animals are being advocated for by ethical vegans. One I'll add to the mix is the rights of prisoners to vegan food. And I'm just wondering, are there other areas in which you see the rights of ethical vegans sort of waiting to be exercised to better protect animals, or the rights of ethical vegans to protect animals?
I think that, well, ideally, if it seems as though Jordi's case, the precedent it sets would just be ideal persuasive authority for many of the cases we see. That we've had a couple, but it just seems as though if we could just have some decisions at the higher levels of courts, whether it seems as though in the workplace accommodations, perhaps with the COVID vaccine, maybe something that might be, because of the animal testing, maybe something that will be challenged. But as you mentioned, the prisons brings in a whole other slew of laws, from whether it be the First Amendment, freedom of religion, to the Eighth Amendment against cruel and unusual punishment. I think and that is sort of a whole area that needs to be worked on still. The federal prisons in this country and in the UK, they're great because they do have vegan. The UK is amazing. They have not only a vegan menu, but even the clothing the inmates wear, the shoes, the toothpaste, everything is vegan. Here, at least the federal prisons have a vegan menu available. But in many states still, unless an inmate can tie that to a religious belief, and maybe that they're not able to eat the regular food, so they're having physical effects. They're hungry, they're very hungry from it. They could point to cruel and unusual punishment. So I think maybe those two areas, still many of the state prisons need work to just make it more accessible, make vegan food and vegan clothing and all of that accessible without inmates having to fight for it so hard in many states. And I think maybe we might see some just more Title VII cases, maybe First Amendment in the workplace.
Thank you both, Jordi and Jane, for those excellent presentations. And this recording will be uploaded to our YouTube channel in the next few weeks. So please, if you missed any part of it or want to catch any part of it again, that's where you can find it. And again, thank you both for those wonderful presentations.
Thank you. Thank you, Jordi.
Thank you.
Thanks, Rhett.